What is law? That was the question. You can see that in any society, certain rules and regulations are formed to regulate the conduct of the citizens or people or the persons in a society, so that law order can be maintained in a society. So the basic definition, very basic definition, is the rules and regulations formed to regulate the conduct of people in a society to maintain law and order and peace. If a country wants to progress, a society wants to progress, peace is essentially required. Therefore, very basic definition of law is the rules and regulations. These rules and regulations can have various kinds of various shapes. So, jurist, who were jurists? Jurists were, those were the researchers, scholars, philosophers of their time who studied law from not point of view the law which we study, but they studied law from the point of its applicability in society, and with the changing scenario in society, how law should evolve. We will later on study how this law is evolved, but at this stage we must know that what are the kinds of law that those jurists were in the process of study. Rather, they were in process of those studies, they were in conflict to each other. That which kind of law is the real subject matter of the jurisprudence. Say, broadly it is divided into two parts. One is man-made law and there is God-made law. In man-made law, it can further be subdivided into two parts: abstract law and concrete law. You know what is man-made law? Suppose you are running a company, and in order to run your company, you are making certain rules and regulations for your employees. That is again rules and regulations. That is again law for those particular employees. Similarly, in a country, whether it is a monarchy or it is a democratic setup where a government is run, so whosoever is there at that position, who has the authority to make law, so those laws are called as the man-made laws. And God-made law means, God-made law is further subdivided into law of nature and divine law. Law of nature means those laws in the earliest possible time where there was no written form of law or legislature. There were certain notions, there were certain rules which were evolved through the nature. Those, there is a supreme power, there is a superpower who is controlling the entire concept of this particular earth. So that particular superpower is given the name God, and God has evolved those rights, those laws. That means law of nature and divine law. Law of nature means physical law. Physical law can be physics, chemistry, because in physics certain phenomena you will observe in the world, and those are given certain names. Say gravity, it is also running under certain law. In chemistry, various formulas are evolved. So with the combination of those elements, some other element is formed, some substance is formed. So that study, that is also comes under certain rules and regulations. So that study is called physical law. Then the natural law. Natural law we will study in very detail, because certain schools is given name as Natural School of Jurisprudence. That we will study there. Now divine law has come from scriptures and religious law. These are religious law. We study our Christian scriptures, holy books, and then from them whatever is written there, we observe that as the saying of the God. And when we say that you have not to do anything which hurts the sentiments of others, you should not cheat anybody. If cheating is not good, stealing is not good, then that particular sort of feeling is given from the divine law. That means those scriptures, this sort of things are written in various forms. Religious laws is also derived from those scriptures. Then third part of this God-made law is moral or ethical law. Law is ought to be and philosophical law. Law is ought to be means a certain behavior should be like this. What it is not the case. Certain behavior should be like this. That is law as ought to be. Philosophical law is definitely a school of jurisprudence is there. That is philosophical school of jurisprudence. We will study it later on. So God-made law is divided into three parts: law of nature, divine law, and moral or ethical law. Man-made law divided into two parts: abstract law and concrete law. Let us see what is in abstract law. Abstract law is nothing but fundamental principles and general notion or ideas which exist in theoretical form without being tied to a specific case or society. So we can say that abstract law are those laws which are having some principal value, but concrete law are those that's a real law, applicable law, statute, act, decisions. Here we can say that all the acts which we study, those statutes, those acts, and those real laws are the concrete law. That means if there is a contract act, so contract act has all the components that how a contract is to be entered, and when a party breaches a condition of contract, then how that particular situation is to handle, how aggrieved party can approach the court, and how that aggrieved party get the compensation if there are breaches proved against the other party. So it is contract act. That means its applicability. These are real laws. These are applicable laws. These are not the fundamental principles. You should not breach any condition of contract is the fundamental principle. But that fundamental principle will not bring any relief to that person who is aggrieved there. Actually, these acts which are having all the various conditions under the circumstances, a party is said to have committed a breach or a party has not committed a breach in a contract act. So applicable laws, real laws, statute, acts, and decisions. What are decisions? Decisions means this is also called precedents. A higher court, say Honorable High Courts and Honorable Supreme Court, whenever passes a particular judgment and it has given a very decisive judgment about a particular aspect, then the lower courts, that district courts and ministerial courts, these courts have to follow those decisions, and these decisions are binding on them. So we can say that man-made laws are abstract laws, concrete laws, these are practical laws, these are actual laws, and there are certain principles on which these particular laws are relying upon. And the last point is the positive law. Law as it is, and it is analytical law. That means here you will see that man-made law is positive law, and in case of God-made law, that is called law as ought to be, and here it is law as it is. That means what is actually a law in a society, that is positive law, law as ought to be, because it has the sanction, it has the authority, it has been passed by the competent person in that particular government or in that particular system. So it is something which is real, and it is not real, it is something imaginary, and one can say that because divine powers and law of nature are derived from the God or some supernatural power, one can say is more related to that what should be in the society, and what is in the society, it is the positive law. So after this analysis, we come to the second part of this particular jurisprudence. So before going further, we must recapitulate that purpose of law: to regulate behavior of people, maintaining order, to protect rights of individuals, to resolve disputes between parties, to provide justice to aggrieved party, act as deterrent to the wrongdoers, and to bring prosperity in country. So these are the purposes of law in any country. Now before going ahead, it is very essential to know why laws are made, how laws are applicable in a society, and what kind of laws are there. So we should know that what are the laws and what kinds of laws are there. So division of law can be made: the public law and private law. Public law is those laws where the aggrieved party is the state, is the society as a whole. Those laws which are governing the society as a whole, they are keeping individuals in mind, but their larger goal is society. So public law means related to society as a whole. Constitutional law is the best example. Constitution governs the structure of the state, government's power. It governs the executive and judiciary's power. It also tells about the fundamental rights. So this constitutional law is very important from public law point of view. Second is administrative law. Administrative law regulates the power, functions, and duties of the government agencies. There are various government agencies. Say CPWD is a government agency, UPSC is a government agency. So when a government agency is there are certain rules to how to operate that particular agency. Like any company, in any company, to regulate the conduct of the employees, employer definitely made certain rules. Likewise, in any organization, rules are made so that discretionary power of that particular officer or person or the institution cannot go beyond the given powers. So discretion must be minimum. The particular person should act, that particular department should act as per law in fairness. Then criminal law deals with offences against the state or society. As the criminal law are any law which is against a person and it is considered as an offence by some act or by law, then it is considered as a crime against the government, the crime against the state, crime against the society, and not against the individual. If a murder happened, that murder of course is of a particular person, but here aggrieved is the society. किसी एरिया में चोरी हो जाती है तो उस एरिया के सभी लोग में एक भय का माहौल आ जाता है कि चोरियां हो रही हैं हमारे एरिया में, या पिक पॉकेटिंग हो रही है, या चैन स्नैचिंग हो रही है. इस तरह सोसाइटी के अगेंस्ट एक क्राइम होता है, और उसको दूर करने के लिए बेस्ट पॉसिबल तरीका ये होता है कि हमें सोसाइटी को इस तरह के लॉज देके एक डेटरेंट की तरह वहाँ पर स्टेट को खड़ा होना पड़ता है. देन प्राइवेट लॉ related to private individuals and entities. That means if there is certain dispute between two private persons, there are dispute between a company and its employee, that sort of dispute will be solved by the private law. So those private laws, entities here is also mentioned along with this private individual. Entities are those anything which a company which is registered by ROC, or which is a private limited company, or it is a partnership company, or it is a LLP. So any company which has given a legal entity by the government, that is also called entity. Contract law governs it. Rules governing agreement between parties. If there are agreement or contract between two parties, if any party cheat other party, then the aggrieved party can go to the court to get the justice. Then tort law. Those laws, those acts which are outside the contractual provisions. That means the relation is not of contractual between two persons, but there is some civil wrong one did. So that for that civil wrong, suppose मेरे पड़ोसी ने पार्किंग की जगह पर कुछ गमले रख दिए, ये कुछ सिविल रॉन्ग हो गया है. अब उस गमले रखने से क्या पार्किंग नहीं हो पा रही है, एक डिस्प्यूट क्रिएट हो गया है, तो वो चीज़ें टॉर्ट के अंदर आएंगी. मैंने कुत्ता रखा है अपने घर में और मैं उसको तरीके से कंट्रोल नहीं कर पा रहा हूँ. मैं शाम को लेके जाता हूँ और वो लोगों को भौंकता है, काटता है, या फिर वो उनको डराता है. तो ये एक सिविल रॉन्ग है जिसके लिए एक रेमेडी हमें मिलनी जरूरी है, तो वो सिविल में ही आपके टॉर्ट के लॉ के अंदर उसकी रेमेडी मिलेगी। देन प्रॉपर्टी लॉ है रिलेटेड टू ओनरशिप, राइट्स, पोजेशन एंड यूज ऑफ प्रॉपर्टी। Property laws are very essentially required because property disputes are in a very large number in our courts. So to resolve those disputes, it is essentially required to make a property law. So second category is a private law. Then comes the substantive law. Substantive law means every right, every duty and obligation of an individual. If it is infringed, that will come under the substantive law. Rights of one person is obligation for other person. That means if I have right to go safe on road, then it is the duty of the car driver or two-wheeler driver or anybody who is driving their vehicle over the road to drive safely, so that a pedestrian who is me at that particular point of time should go home safe. That means this particular aspect is that one's rights are others' obligation and reciprocal, vice versa, one can say. So duties are also to be followed. So law is threat, fraud. These are some of the things जिसके अगेंस्ट जो लॉ बने हैं उनको हम सब्सटेंटिव लॉ कहते हैं। और सब्सटेंटिव लॉ बहुत इंपॉर्टेंट है क्योंकि सब्सटेंटिव लॉ एक इंडिविजुअल की जो अपने राइट्स होते हैं उसकी जो अपनी जो एक फ्री विल से जीवन जीने की शैली होती है उसको रोकने में सब्सटेंटिव लॉ बहुत ही इंपॉर्टेंट है कि वो उसको इंडिविजुअल तरीके से अपने तरह से फिर फ्रीडम के साथ में जी सके, वो बना सके। नेक्स्ट इज प्रोसीजरल लॉ, बट बिफोर कमिंग टू प्रोसीजरल लॉ आई वुड लाइक टू कम टू सिविल लॉ एंड क्रिमिनल लॉ। एज इज ऑलरेडी बीन सेड, द सिविल लॉ डिस्प्यूट्स बिटवीन प्राइवेट इंडिविजुअल एंटिटीज, say contract disputes, property dispute, family law, Hindu law, Muslim law, these all will come under civil law. And criminal law are those which are the offenses against society and state. And to punish the wrongdoer, to deter the wrongdoers, to maintain social order, these criminal laws are made. So all sort of laws are there. That means I have public law, I have private law, I have administrative law, I have criminal law, I have civil law, I have substantive law. But what to do with those substantive law? What to do with those criminal law? What to do with those civil law? If something wrong happened, then to whom I should approach and how I will get the justice? So the procedural law comes into the picture. It is the most important, that is procedural law. Procedural law is the most important aspect of law because it gives the method, it gives the process for enforcing substantive law, civil law, criminal law, such as filing of FIR, then court procedure, then rules of evidence. So whenever any wrong is done by a party, then the aggrieved party can get justice by adopting the procedure given in the procedural law. Our CPC, that means Civil Procedure Code, CRPC, earlier it was CRPC, now it is BNSS, and Evidence Act, these all comes under the procedural law. So procedural law is something which is essentially required to provide justice to the aggrieved party. So these 6 laws are the primarily most important laws. Other than this, customary law. Customary laws, those laws which are not having, which do not have any sanction of the government. These cannot be enforced by state, but this is something which is accepted by the society as a course of action, as a pattern of life. That means in this case one can say the customary law are those laws that arises from long-standing custom and practices recognized by society. Such customs must be in operation continuously for a long period without any objection or dispute. That means such customs must be in acceptance with the society's total acceptance of society. Say sati was one of the customs, but it was not fit on the humanitarian ground, so it was rejected. Similarly, other customs like child marriage is also one of the which is not accepted by the governments because it is not good for the health of both the child. Likewise, there are many other customs which are gradually depleted by the society, removed by the society. Untouchability was one of the curse on the society. which is removed by the constitution. So they removed those, they screened those customs which were not good in spirit and which were against a particular sex or a particular caste or particular creed. So it is not that customary law is acceptable if it is accepted 100 years or 200 years ago. No, it is also, it is accepted by the governments. It is under scrutiny. Then moral law. Moral laws, those laws which do not have any sanction of the government, but it is in morality, people feel so that giving respect to elders, it is something which is accepted by all the members of society. So it is something which is based on the moral grounds, not on some sanction of the government. Then municipal law and international law. Municipal law doesn't mean that कि नगर निगम ने जो लॉ बना दिया है वो म्यूनिसिपल नहीं. म्यूनिसिपल लॉ को विसाविस इंटरनेशनल लॉ के साथ में देखने की जरूरत है. म्यूनिसिपल लॉ से मतलब बॉडी ऑफ डोमेस्टिक लॉज गवर्निंग इंडिविजुअल्स विद इन ए स्पेसिफिक कंट्री और टेरिटरी. तो टेरिटरी और किसी भी कंट्री के अंदर जो उसके डोमेस्टिक लॉज होते हैं वो सारे के सारे लॉ जो है म्यूनिसिपल लॉ के अंदर आते हैं. प्रॉपर्टी कैसे परचेज करनी है, प्रॉपर्टी कैसे सेल करनी है, आप कहीं नौकरी लेते हैं किस तरह से लेते हैं, आप सड़क पे चलते हैं किन लॉज के अंदर चलते हैं, आप बैंक में किस तरह से प्रोसीजर कर सकते हैं, कैसे आप अकाउंट खोल सकते हैं, कितना अमाउंट आप कैश में डील कर सकते हैं, कितना अमाउंट आप कैश में नहीं डील कर सकते हैं, आपको किन किन इनकम टैक्स देना आपकी ड्यूटी में आता है, ये इंडिविजुअल कितने % का स्लैब आपके ऊपर लगेगा इनकम टैक्स में, ये सब आपके डोमेस्टिक लॉज है. ये इंटरनेशनल नहीं, डोमेस्टिक है. उस कंट्री में अगर कोई बाहर का फॉरेनर आएगा वो वहाँ पर वो रहेगा तो ही हैज़ टू फॉलो दोज लॉज. तो वो ये नहीं कह सकता इग्नोरेंस ऑफ लॉ, ये मुझे मालूम नहीं था कि इस तरह का लॉ यहाँ पर है क्योंकि उनकी कंट्री में नहीं है. तो इसलिए म्यूनिसिपल लॉज आर वेरी इंपॉर्टेंट व्हेन इट कम्स इनटू द इंटरनेशनल लॉ प्लेटफॉर्म. इंटरनेशनल लॉ क्यों बने? इंटरनेशनल लॉ इसलिए बने कि नाउ यू सी इफ देयर आर 200 odd countries in this world, some are very strong and some are very weak. So स्ट्रॉन्ग कंट्री वीक कंट्री के ऊपर उसकी सॉवरेंटी के ऊपर अटैक ना करे और एक लॉ एंड ऑर्डर उनके बीच में मेंटेन रहे, एक ह्यूमैनिटेरियन ग्राउंड के बेस पे वो इक्वल फुटिंग पर एक दूसरे को ट्रीट करें, चाहे वो ट्रेड में करें, चाहे वो वॉर फ्रंट पे करें, चाहे सिक्योरिटी के लिए करें. इन सब चीज़ों के लिए बनाए गए थे इंटरनेशनल लॉ. अब जैसे कि वर्ल्ड है, वर्ल्ड में कंट्रीज भी हैं और 70% सी पोर्शन में सी है. अब सी का जो पोर्शन जहाँ पर दो कंट्रीज आ रही हैं उनके बीच में अगर सी है तो उनके किस रेंज तक, कहाँ तक उसकी, जैसे 12 नॉटिकल माइल तक उसका एरिया माना जाएगा जिस पर्टिकुलर कंट्री के कोस्ट में वो पोर्शन सी का आता है. और उसी तरह से अगर दो कंट्रीज के बीच में 12 नॉटिकल माइल से कम का डिस्टेंस है तो उसमें कितना एरिया दोनों का माना जाएगा. ऐसे ही आप एयर स्पेस का भी यूज़ करने की बात है कि एयर स्पेस माई कंट्री के ऊपर से दूसरे कंट्री का अगर कोई एरोप्लेन निकलता है तो वो मेरी परमिशन से ही निकल सकता है. तो वो जब वॉर टाइम होते हैं, अभी पाकिस्तान के साथ में लड़ाई हुई तो उस समय सारे के सारे एयर स्पेस को ब्लॉक कर दिया गया था, किसी की भी एंट्री परमिटेड नहीं थी क्योंकि वो दैट कैन बी डिटरमेंटल टू द सिक्योरिटी ऑफ द कंट्री. इस तरह से इंटरनेशनल लॉ जो थे वो बनाए गए. इंटरनेशनल लॉ इन्वायरमेंट पर भी बनाए गए हैं और चूँकि इन्वायरमेंट जो पूरी ग्लोब को एक ही माना गया है और एक कंट्री के अगर ज़्यादा उसका इन्वायरमेंट को नुकसान पहुंचाता है तो उससे एंटायर वर्ल्ड के फर्क पड़ता है और ऐसा ऑब्जर्व भी किया जा रहा है. तो इंटरनेशनल लॉज ट्रीटीज़ को एक डिफरेंट सब्जेक्ट है जिसमें कि हम स्टडी करेंगे. हम सब्सटेंटिव लॉ या प्रोसीजरल लॉ, सिविल लॉ, क्रिमिनल लॉ और हमारे जो दूसरे एक्ट्स हैं जिसमें कॉन्स्टिट्यूशन लॉ वगैरह हैं, ये सब डिफरेंट सब्जेक्ट्स के अंदर स्टडी करेंगे. तो आज हमारा इसको एक्सप्लेन करने का जो मेन पर्पज़ था वो पर्पज़ ये था कि हम ये समझ पाएँ कि किस किस तरह से लॉ बने हैं, किस किस तरह के लॉ डिफाइन किए गए हैं, किस तरह से लॉ का डिविजन्स हुआ है. और नेक्स्ट उसमें हम ज्यूरिस्प्रूडेंस को अब हम जो पढ़ेंगे उसमें क्या क्लासिफिकेशन ज्यूरिस्प्रूडेंस के किया गया है.